Hi, everybody. I'm attorney Jason McGrath. How are you today? I've been a litigator for 20 years now, have handled all kinds of lawsuits, and I'm looking forward to explaining a little bit today about requests for production. If you're in a lawsuit or expect to be in a lawsuit, then you're likely going to be on the propounding end, the sending end, or the receiving end of requests for production. And typically, this is a function of our discovery system within the judicial system. It's governed by the rules of procedure. And here in North Carolina, which is particularly what I'm talking about, you have the opportunity, as you do in most states, to go ahead and ask the other side or ask some other party to provide documents. And this typically is done by way of a written request called a request for production or a request to produce. We call it an RFP or an RTP for shorthand, acronyms and such that we love. And basically, you're just saying to the other side or to some other party, please produce X, Y, and Z. And you want to, typically include, please provide us with true, accurate, and complete copies of A, B, C, D, E, F, whatever it is. And the more specific that you are, probably the more specific the responses will be. Of course, you might get objections, or if you're on the receiving end, you might go ahead and file objections. There are time limits involved. Typically, it's 30 days. So if you're sending out a request for production that say it asks for 10 different items, you're going to want a calendar that the response to that is probably due within 30 days. If you've received a request for production, then you're going to want a calendar, hey, I need to respond to this within 30 days and either provide those documents or reach some kind of agreement with the court or with the other side that I get more time to respond, or I need to file some objections or take some other action. And one thing to be careful about is if there are proprietary or private or confidential documents that you don't want produced, well, you ought to file an objection, but you also ought to file a motion for protective order. Or if you're trying to get documents that might be confidential, you might expect to get a motion for protective order where essentially the party that doesn't want to produce the items is asking the court to say, hey, please enter an order that says I don't have to produce these, or an order that says that if I do have to produce them, that there's some kind of confidentiality so these are not public record, at least at this point in time. So of course, any documents that you get or that you send as a result of a request for production can typically, unless there's some court order or statute that says otherwise, typically they can be used in depositions and trials and other court hearings or events. So you have to be very, very careful in what you're providing. You have to be careful what you're objecting to, and you have to be very well considered in what you're asking for, why you're asking for it, or why you're producing or attempting to not produce certain items. But that's a request for production in a nutshell. Thanks.